which is, I say by way of contrast, for example, with that of Germany. And what happens there? Article 25 of their written constitution, which I've taken from an established work on public international law, states as follows. These are the words of the very constitution in Germany. The general rules of public international law are an integral part of federal law. They shall take precedence over the laws and shall directly create rights and duties for the inhabitants of the federal territory. Similar provisions, for example, apply under the Dutch Constitution, Articles 65 and 66. So what does this tell us? That there is a dualist system and that some countries take a view which is different from ours. We just happen to be on the right side of the fence. Similar provisions may be applied by specialist international lawyers, and they may seek to make out that international law in this country prevails over clearly explicit words in acts of Parliament and parliamentary sovereignty. But there is no House of Lords or Supreme Court case which supports this proposition. I give way.
Very much enjoying his speech as always, and he gave the example of Germany, but even for obvious historical reasons, they've imported principles of international law into their own domestic constitutional law. For example, the German Supreme Court, the Federal Constitutional Court, still reserves its right to be the final arbiter whether, for example, European Union law is incompatible with the German basic law.
Well, I'm extremely glad that my right honourable friend has made that point, because actually I had the disobliging necessity to read some of the Supreme Court judgments from Germany, and believe me, sometimes they run to nearly 1,000 pages for the very simple reason that they're struggling to find something which will support the German people as compared to some of the rules of law which are applied more generally from on an international footing, which causes them so much trouble. So, as I've said, the European Union, and the point my honourable friend just made makes my point for me, is itself in a complete mess on this issue of illegal migration, and we are well out of it. It still has the Charter of Fundamental Rights, which we excluded in our withdrawal agreements, and legal changes to its immigration law, all of which will require hotly contested constitutional changes and referenda in its member states. They're going to be bedevilled by referenda, by constitutional change. I fear they will not succeed. Very many are up in arms about compulsory quotas and fines for non-compliance being imposed upon them under the new Asylum Pact, Immigration and Asylum Pact, and which was passed by a majority vote. And it's noteworthy that recently the French government defied rulings of the Supreme Court regarding the deportation of an Uzbek national, but cannot apparently trace him as ordered by their own Supreme Court. By reference to the barracking I'm receiving at the moment, I'd simply point out the relevance of this is that we're talking about our constitution, which can solve the problem, and theirs, which cannot. I certainly will.
Of course, he's making a compelling argument about the difference between this country and those abroad who failed to take back control when we did. And he will know that constitutionalists from Dicey to Denham, from Lord North to Northampton, agree with him that this place is supreme, and the supremacy of Parliament is at stake as we debate his amendment and this bill.
Well, I have to say with all humility, if I may, that it's not so much that I agree with them or that they agree with me, but that this is the law of our land, this is the rule of law as it applies to the United Kingdom. And it is a tribute to the British people that they took that decision in 2016. As I said to the Prime Minister in December's Liaison Committee meeting, he himself can be a world leader on this illegal migration issue, not only in the EU, but also in the United States, in Canada, in Australia, every country in the world. The International Refugee Convention, among other conventions, is seen as requiring reform. And in Europe, it is clear that they need to change the European Convention on Human Rights, as well as EU immigration law, and the European Union voters are voting with their feet. This bill, nor the amendments are in breach of the present Refugee Convention. as this convention does not prohibit states outsourcing asylum claims and settlements to a third country. Similarly, the European Convention does not prescribe how its rights and freedoms are to be secured. Moreover, there has been, and I quote the words, a fundamental change of circumstances in the increase of illegal migration, criminality, and the deaths that these have incurred since the convention was created. So it is clear that the currently described obligations, as they're put, must take account of this change. We have to keep up with the times. And mass immigration is one of the main issues before all nations. So what is more important? Passing a bill that works and is consistent with the democratic will of the people and the national interest, our constitutional arrangements and parliamentary sovereignty, or supporting the uncertainties and vagaries of international law. Far from diminishing our international reputation, we now have the opportunity to enhance it by demonstrating that we can deal with illegal migration by making this bill work through our own parliamentary sovereignty. And we can bring an end to the deaths in the Channel. It has also been suggested, I have to say, that it is improper and contrary to the ministerial code to bring in a bill which is inconsistent with international law. This seems to permeate the legal establishment of this country. This is nonsense on stilts, because any member of parliament, any unimportant member of parliament, as well as ministers, any backbencher can propose legislation, and private members' bills are enacted frequently, as I have to say, even with my International Development Act of 2014. The acceptance by the noble Lord, the Lord Cameron of Chipping Norton, when he was Prime Minister, despite resistance from the legal establishment at the time that we could refuse prisoner voting, as insisted upon by the Strasbourg Court, is well known and remembered. The former Lord Chancellor and Secretary of State for Justice, the Right Honourable the Lord Clerk of Nottingham, King's Counsel, said that when we refused to accept the, quote, international obligation under the European Court of Human Rights to allow prisoners to vote in elections, he said that, quote, sorry, I mustn't laugh, prisoner voting was a particular political issue. So what about illegal migration? The 2023 House of Lords report makes much of the Ministerial Code and the Civil Service Code, stating, and I quote, that while Parliament is ultimately responsible for the form of any legislation passed, the preparation and introduction of government legislation is an executive action for which ministers collectively are accountable. They then go to reaffirm their disquiet about the constitutional desirability of Parliament legislating in violation of UK international obligations. But they ignore the principles of parliamentary sovereignty, where words in acts of Parliament are used and are clear and unambiguous. And moreover, the Ministerial Code is a convention, not legislation. The words in that code, some 10 years ago, did, once upon a time, state that the Ministerial Code included the words, quote, an overarching duty on ministers to comply with the law, including international law and treaty obligations. But these were expressly removed from the code in 2015 by the then Prime Minister. The current 2022 Ministerial Code under the present Prime Minister simply refers to the law. This is no accident. The government has declined the Lord's invitation to bring back the words, quote, international law and treaty obligations, and I would say, quod erat demonstrandum. The House of Lords Committee also suggested, in reference upon a Court of Appeal case of the Gulf Centre for Human Rights against the Prime Minister in 2018, and a statement 5 years ago by the noble Lord and distinguished Lord, the Lord Folkes KC, that the Ministerial Code still requires compliance with international law obligations. However, I have to say, the Court of Appeal, sadly for them, did not deal with the issue of parliamentary sovereignty, which would be combined with the use of words clear and unambiguous, and in any case did not concern an act of Parliament. Failure to pass a bill to effectively deal with illegal migration has led to vast public expenditure, billions on services including healthcare, education, social care, housing, infrastructure, planning, just to name a few, not to mention millions and millions on hotel bills. This is why people are so cross, as well as the fact of illegal migration. There is no reason whatever why this bill should not expressly and clearly exclude international law for and within the reasons I have given. It is an affront to Parliament and to the courts to suggest otherwise. I therefore ask that my amendment be voted upon and passed by the House, and I strongly urge the government to note the sheer anger and frustration demonstrated in opinion polls and public concern that we get this bill right and make it work. If not, this anger will continue up to and including the general election. Would it not be wise for the government to reflect on the position, and that it would be better and wiser to come forward with their own amendments and use our majority in line with our manifesto, granted to us by the general election in 2019 and in the national interest, and for the sake of all Conservative members of Parliament whose seats will be so at risk if we do not do so.
Yeah. Dave Diana Johnson.
Thank you, Sir Chair. I'd just like to start by raising my concerns with the government about using a committee of the whole House for this part of the scrutiny of the bill. We had this with the Illegal Migration Act, and what happened was, in that case, there were hundreds of amendments, and the Minister just got to speak at the end for a very short period of time. Now, I think when we're debating and scrutinising bills like this, we need to do so line by line, and we need to debate, and we need to hear the argument from the Minister and the argument from the proposers of amendments. And I just think that this process that we're going through does not allow Parliament to conduct that effective scrutiny that we all want to see when passing laws in this place. So, turning to the bill before us today, when the Home Affairs Select Committee published our report on Channel Crossings 18 months ago, we were very clear about the potential problems posed by the Rwanda scheme. And as I've highlighted on several occasions in this chamber, we said that the small boat crossings is an issue on which no magical single solution is possible, and on which detailed, evidence-driven, properly costed and fully tested policy initiatives are by far most likely to achieve sustainable incremental change. We warned the government that it risked undermining its own ambitions and the UK's international standing if it could not demonstrate that the scheme was compatible with international law and conventions, and that aspects of it carried significant reputational risk to the United Kingdom. Now, contained in the amendments today that we're debating are provisions that not only are incompatible with the UK's obligations under international law, but to basic principles of liberty and freedom under common law. The implications of these amendments are therefore profound and affect, I think, every single one of us. And also, despite what the former Immigration Minister said, I do take in all sincerity what the Rwandan government's view is on the importance of upholding international legal obligations. We can conclude that some of the amendments tabled today would prove fatal to the implementation of the bill, and indeed yesterday the UN Refugee Agency declared that the Rwanda Treaty and this unamended bill are, I quote, not compatible with international refugee law. So I want to speak to amendments 2, 3, 10, 56 and 57 and then focus my comments on amendments 19 to 22. Turning to amendments 2 and 3, excuse me, they would prevent any claim based on risk derived from individual circumstances being considered until that person in question had arrived in Rwanda. This would effectively exclude the very narrow possibility for suspensive claims that the bill currently allows, and could result in the person being exposed to the risk on which their claim is based, including claims based on fear of persecution and torture before it's even considered. The European Convention on Human Rights requires independent and rigorous scrutiny of any claim that there exists substantial grounds for fearing a risk of treatment contrary to Article 3. It also requires that the person concerned should have access to a remedy with automatic suspensive effect. So these amendments would therefore be inconsistent with that requirement of the ECHR. Moving on to Amendment 10, that would extend the notwithstanding provision to apply to all of the bill and to the Illegal Migration Act. It would effectively prevent a claimant relying on any pre-existing legal protection to prevent or delay their removal to Rwanda. This amendment would expressly allow for a removal to Rwanda despite that removal otherwise breaching domestic law and despite that removal being in breach of international law, including fundamental human rights, from which, of course, we know no exception or derogations are permitted, such as the prohibition on torture. Needless to say, this amendment is not compatible with the UK's obligations under international law and risks undermining our international standing. Amendments 56 and 57 would provide that courts and tribunals would not be permitted to consider a claim on the grounds that Rwanda is not a safe country, where the claimant has engaged in activity or made serious allegations that have brought into question the safety of Rwanda, or colluded or conspired with others who have done the same. Very worryingly, the amendment appears to exclude people who have made serious allegations about the safety of Rwanda from asylum and human rights protection. This would be inconsistent with rights to asylum and humanitarian protection under international law, and could also be inconsistent with freedom of expression as guaranteed under Article 10 of the ECHR. I just want to turn to Amendments 19 to 22, amendments that I think have profound implications for all of us. Those amendments would prevent any individual set to be removed to Rwanda arguing that they could not be sent there on the basis of their own circumstances. In the inevitable absence of absolute certainty that no risk to any individual could arise in Rwanda, this would mean that legitimate claims based on a real risk of persecution and human rights violations would not be heard, and that those people whose claims are unheard would be removed to face that persecution and human rights violations in Rwanda on which their claims are based. This is clearly inconsistent with the Refugee Convention, the ECHR, and the other international legal obligations cited by the Supreme Court in its recent judgment. Amendment 22 would also prevent the courts from reviewing not only asylum claims of individuals being sent to Rwanda, but also claims for unlawful detention, for assault in the course of removal, or for discriminatory treatment in the course of the removal process. So I just want to be clear, denying these claims would not only be inconsistent with human rights law, but also with fundamental principles of liberty and freedom under our common law, which has been protected for centuries, including by the writ of habeas corpus. And all members who do not want to see habeas corpus sacrificed today can surely not sacrifice these particular amendments. Finally, I'd just like to add my voice to amendments that I believe to be sensible and logical revisions. I'm just going to carry on because I want to deal with Amendment 1, which requires the Secretary of State to monitor whether Rwanda remains a safe country, and New Clause 6, which places conditions on when the classification of Rwanda as safe can be suspended in accordance with material conditions and or non-compliance with obligations. I'm willing to give way.
The Honourable Lady for giving way, and Right Honourable Lady for giving way. She will know that under this government and previous governments of all political colours, many people are deported from this country. People who are here illegally. When that happens, invariably, it is notwithstanding claims they make about their circumstances. Sometimes those are claims about their personal circumstances, sometimes they're claims about the place they're being deported to and from where they come. On the basis of her speech so far, she would deport no one.
I don't know if I am grateful to the Right Honourable Gentleman for that intervention, because that's clearly not what I'm saying. What I'm saying is, and the Home Affairs Select Committee is very clear, is about the rule of law, recognising the international obligations that this country has freely entered into, and doing things properly and legally. And that's what I'm questioning, that some of the proposals that are being put forward today by honourable members opposite are going to the heart of the common law that we have in this country, and our belief in the right to go before a judge, to particularly if one is detained, that you cannot be detained indefinitely. These are important matters before us today. I want to just carry on, because there's a couple of other things I want to get into the record. Just going back to what I was saying about Amendment 1 and New Clause 6, I think while the government has determined in this bill that it's possible to stipulate in law that Rwanda is safe, to the contrary of finding a fact by the Supreme Court, as we know, it doesn't seem to me very sensible for the government to propose that that status should be fixed forevermore, with Rwanda, by extension, the only country on earth in which nothing can ever happen or change. So as such, Amendment 1 and New Clause 6, I think, have merit, which I hope the Minister will consider. Amendments 35 and 37 allow the courts to consider the risk of refoulement in decisions on removals to Rwanda. And given that the Supreme Court ruled unanimously that the Rwanda policy was unlawfully, precisely because there were substantial grounds to believe that refoulement could take place, I also think that Amendment 35 and 37 have merit. Now, I understand from media reports that the Minister, when he gets to his feet today, is going to make give some undertakings about increasing the number of lower level judges, or I should say moving lower level judges up to the upper tribunal to hear any appeals, and this apparently is to deal with some of the concerns that honourable members on his side of the House have. I just wanted to say to the Minister that the Home Affairs Select Committee is very concerned generally about the lengthy delays in court cases, and particularly in one of our recent reports on the investigation and prosecution of sexual offences, and particularly rape. We were very worried about how long it was taking for those cases to be heard. So this initiative that the government have come up with, or perhaps I'm prejudging what the Minister's going to say, but it's being reported in the press, I am very concerned that there's this amount of resource and finance that's going to have to be put into training up this 150 number of judges. It does strike me that the government seem to be using an enormous amount of political time, resource on this particular policy, and I'm looking forward to what the Minister has to say about this issue of increasing the number of judges when we seem to have so many other problems in other parts of the court system that the government haven't so far been able to deal with. And I also, at that point, Sir Roger, I think that concludes my remarks on the amendments that have been tabled today.
5 minutes. Sir Robert Buckland.
Thank you, Sir Roger. It's a pleasure to follow the Honourable Lady, the Chair of the Home Affairs Select Committee. I rise to speak to Amendments 28, 29 and 30 tabled in my name, relating, although they relate to Clause 9, they relate to the operation of Clause 2, hence their selection for debate today. And I think it's important that we focus in Clause 2 on what that actually means, what its effect is, what the changed reality is with regard to the position in Rwanda, and indeed the position between the United Kingdom and Rwanda, since the not just since the decision of the Supreme Court in November, but the facts upon which the Supreme Court based their decision, which of course relate to the spring, early summer of 2020. 2022. There is no doubt that matters have moved on, and moved on quite significantly. Not only do we have a treaty between the United Kingdom and Rwanda that was signed late last year, but we also now have, in the form of a policy document published by the government, and indeed further information, an indication as to the hard and fast changes that the Rwandan government in particular will be making in order to, in effect, answer the questions asked of it by the Supreme Court decision. Because, Mr. Sir Roger, the Supreme Court decision really wasn't about the law, it was about the evidence. And when we look at what the Lordships decided, the Supreme Court justices rather decided, it was very much narrowed down to that issue of whether or not refoulement was still likely, bearing in mind the position of Rwanda. Now, the court decided that it was. That's the sole reason why the policy was held to be unlawful. There were other grounds that were tendered in that case. One on retained EU law was a specific ruling of the court that, of course, it didn't apply. The law was very clear that that part of retained EU law had fallen with our departure from the EU. Other aspects of the claim, the appeal, were not ruled upon by the court. So it wasn't a decision based upon compatibility with the ECHR, for example. It wasn't a decision, importantly, that was based upon a challenge that was upheld to the legality of the removal of people to third countries. In my view, it's neither illegal nor immoral to move to seek third country assistance when it comes to this unprecedented challenge. Other European countries are indeed either doing it or wish to do it. And as my right honourable friend, the member for Newark, said in his remarks, he's right to say that other countries are looking to what happens here with regard to the precedent that we might set. In setting precedents, we have to tread carefully, Sir Roger. And that's why the amendments that I've tabled are very much focused towards the factual reality and the need to make sure that Rwanda does indeed carry out its policies. And looking carefully at the policy statement, there are particular tasks that will need to be completed. First of all, new operational training for decision makers in Rwanda. I think the latest figure that we have is that over 100 people have now been trained to implement the deal, and that there need to be clear standard operating procedures with regard to the reception and accommodation arrangements for asylum seekers, safeguarding of their welfare and access to healthcare. And of course there needs to be strengthened procedural oversight of the Migration and Economic Development Partnership that was agreed in 2022 and the asylum processes under it. And that means that bodies have to be set up. The new MEDP Coordination Unit, the MEDP Monitoring Committee of Experts, and the involvement of experts, certainly in the early days of the decision-making to be made by the new body at first instance, which will be set up by the government of Rwanda, and a new appeal body that will consist of panels of 3 judges with subject matter experts, including Rwandan judges and indeed judges from other Commonwealth jurisdictions. All these details are important because they go to answer the question that I think will be in the affirmative, that individuals in this scheme will not be at risk of refoulement, and therefore there will not be a breach of the 1951 Convention. That reality has to match the deeming provision. And I know that my right honourable friend, the Minister, will be anxious to make sure that deeming provisions do not either perpetuate or encourage fictions, legal fictions. This is difficult law. But it's not unprecedented. Deeming provisions are, of course, used. They're very often used in tax legislation, and the leading authority is a fairly recent one, Fowler and Her Majesty's Revenue and Customs back in 2020, where it was made very clear by the Supreme Court, I think it was Lord Briggs, who said that deeming provisions creating statutory fictions should be followed as far as required for the purposes for which the deeming provision was created. But what will not be encouraged is the production of unjust, absurd or anomalous results. That's clearly something where the courts do not wish to tread and don't wish to encourage, and neither should we as a government or indeed as a parliament. And that's why making sure that we dovetail the coming into force of these deeming provisions with the reality on the ground in Rwanda means that we're not, in effect, creating a statutory fiction. We're creating a series of facts that is then reinforced by statute. And I think it's that degree of care. And it doesn't have to take ages to do. This can be done in weeks, bearing in mind the quick work that's been done already. This, I think, will go a long way to satisfy the natural concerns that many of us will have about the use of such provisions. We understand why it has to be done. We don't oppose the principle of its use, but we, and I certainly simply just caution that we take care to make sure that we get that coordination right. And now, many of us have been down the road before about ouster, and it can take many different forms. There have been examples, Sir Roger, where ouster proceedings and ouster clauses have clearly not worked. And indeed, it's not the sole province of this government. We saw previous Labour governments try to enact very bold and sweeping ouster clauses, only to find their efforts fell flat, either before the Act became law or indeed as a result of court intervention. I can think of the Asylum Bill of 2004, where Labour tried to be too extensive and expansive. And that's why experience has taught us that where we have very clearly defined reasons, and importantly, where there are limited exceptions, then ouster clauses will work. And we had a recent example of that in the removal of the carte jurisdiction, the Judicial Review Act that my honourable and learned friend, my right honourable and learned friend, finished the job on, which I started the job on in the consultation on the Judicial Review provisions that my noble friend Lord Folkes and others embarked upon at my direction. And that worked. It's been tested not just in the High Court but now in the Court of Appeal in the Oceana case, and it's held to be sound and watertight. Why? Because there was a very clear rationale behind it, and secondly, there were limited exceptions. And herein lies the danger, I'm afraid, that is posed by the otherwise well-intentioned amendment by my honourable and right honourable friends. If you don't have those limited exceptions, you're setting this up to fail, Sir Roger. And that's what I think history has taught us. I'm absolutely a proponent and a strong believer that it is from this place that the core of our constitution comes. It is from Parliament that our constitutional authority is derived, and that to contradict the honourable gentleman member for Aberavon, who in many respects, I think, characterised and couched his remarks well, we're not a separation of powers constitution. We're a checks and balances constitution where each part of the body politic respects each other. And here I agree with him. I think restraint is an important principle. And I'll give, well, of course, to my right honourable and good friend.
My right honourable friend is making a very profound and important point about the nature of the separation of powers, and there is a lot of misunderstanding about this abroad. The separation of powers is not about equal bodies. It's not about each of those bodies performing the same role. It is entirely a matter, as he describes, of a balance between those bodies, and this House is the body that makes laws. Judge-made law is something he and I have debated and discussed and agreed on many times, and it is invidious because this House, as I said earlier, is supreme when it comes to making or changing law.
I entirely agree with my honourable friend, and he and I are both romantic Tories of an old school, which might surprise many members in that we do share that common fount of Toryism that is important to us both. And within that, we utterly respect the independence of the judiciary. It is a separate part of our constitution, and the idea that, as sadly in the Post Office case we've had to, that we trespass upon their domain is something we do extremely reluctantly, and I hope in a very rare and unique way in that very tragic and scandalous example. But that, as he says, does not mean that we are a carbon copy of the United States. In fact, the United States Constitution is itself based upon a misunderstanding of the British Constitution. And it is not right to say that separation of powers is the underlying principle. That fiction, I'm afraid, led us into error when we, to my mind, regrettably took the House of Lords Judicial Committee out of this place and pretended that somehow it was entirely separate from Parliament. The point about the House of Lords Judicial Committee, if I may digress for a nanosecond, Sir Roger, is that it was a body of Parliament making law. And that, I thought, was an elegant solution, an elegant response to our unwritten constitution. The same goes for the office I used to hold. What a mess the previous Labour government made of reform to the office of Lord Chancellor, which I thought was the embodiment of the checks and balances that we have in our constitution. It's a bit of cod philosophy that is overused and is not actually part of our system. But I will go on to qualify that in an important way before I give way to my honourable friend, the member for Gloucester.
But I just want to bring him back, in a sense, to the amendments today. And does he agree with me that between the absolute conviction of the Honourable Member for Aberavon and the opposition that this cannot ever work, and the absolute conviction of the Right Honourable Member for Newark that he can only work with his amendments, there is actually a landing